Thanks for the chance to be here, and it's great to see Danelle Taha. Danelle was my boss, the dean at Pepperdine for a year that we overlapped. My last year at Pepperdine was her first year at Notre Dame. She is not at all responsible for the reason that I left Pepperdine. But thank you for Danelle for being here. And Elise, the last time Elise and I were together, we were at a table representing the United States at the OECD with 35 other countries around us. So it's good to see Elise as well working for the FTC. So far our discussion is focused on, sort of nitty-gritty economic analysis, legal analysis to specific antitrust cases and what we think the trends are with respect to antitrust enforcement within the United States. I'm going to step back as the Deputy Assistant Attorney General for International to focus on the landscape of where I think we're headed globally with respect to antitrust enforcement. And I would say two things. One is, everywhere I would travel around the world for the 2 years that I was a deputy, you could not get away from big tech, right? So her topic on big tech, I think, is the sort of topic of the moment. It's already been discussed in several other panels. That is the big emerging topic that everyone is going to be focusing on. So I'll look forward to her comments in that respect. The other big topic of the past 2 years is how to promote due process, fundamental due process, in the way that antitrust agencies enforce their laws. And that's, I think, been just an incredibly significant development in the past few years with respect to that. So I'm going to focus on that and then leave it at least to talk about big tech. So background in terms of antitrust enforcement. There is no such thing as international law of antitrust enforcement, either substantively or procedurally. There's no such thing as substantive international law with respect to antitrust, and there's really no such thing as procedural international law with respect to antitrust. Contrast that with the trade world, for example, or intellectual property, where there's organizations, there's treaties, there's dispute settlement bodies. There was a huge effort in the early 90s to bring competition law into the WTO and to try to find a way to basically create a system of uniformity with respect to the enforcement of antitrust laws. But the fact of the matter was that there was significant enough divergent viewpoints with respect to antitrust law that there was no real traction to have antitrust laws embedded into the WTO. So the alternative to that was what? Well, we have essentially a really informal network of competition agencies around the world. It was established with the impetus of the United States. The FTC and the DOJ were really instrumental in creating this informal network. The informal network is called the International Competition Network. It originally started in 2001 with about, I think, 19 founding members, 19 agencies that were founding members of it. But essentially it was Europe and the United States, North America, Mexico, Canada, and a few Asians like Japan and a couple others. It was a relatively small elite club. So in that period, you had basically just a few key countries that were doing that. But what's happened is with the global embrace of market economics, with the global embrace of capitalism broadly, you have seen the corollary to embracing markets is the need to deal with market failures, right? Meaning you have to have antitrust law. You cannot have market-based economies without some way to have a corrective for the abuse of markets. And so as a result of that, you've gone from approximately 25 agencies in the early 90s that were, of any significance enforcing antitrust laws in the early 90s to now 140 plus. So 140 countries around the world have competition law enforcement mechanisms, and those enforcement mechanisms are really increasingly becoming robust, which means that you have a major merger like Bayer Monsanto, and you'll have 15 or 20 countries that are reviewing that merger to see if they're going to approve the merger, and you have to get approval in all of those countries. And if you don't get approval in one of those countries, the merger doesn't go through, right? So that happened. It's amazing that it's not talked about more, but in the recent Qualcomm attempt to merge with a Dutch company, every country in the world approved the merger except one, and China refused to approve the merger, and it collapsed. The merger collapsed because of the fact that China would not approve the merger. And there was a lot of discussion with the Chinese about why that. Their official position is that they were open to further discussions, but most people think that it was collateral damage to the trade war. You know, we have so many chits we can play on the tariff side. They don't have as many chits they can play on the tariff side, so they can use non-tariff retaliatory measures, and one of them was to block the merger in the Qualcomm case. So that's an example of essentially industrial policy or national champions or things like that impacting the way merger law is enforced. So there was a perceived need, there has been for over a decade, to really try to standardize and create a uniform process by which we enforce antitrust laws, procedurally. And so in the early Obama years, Christine Varney gave a very well-known speech in 2011 saying we need to really promote uniformity with respect to due process. The problem was that there's wasn't an easy way to achieve that within the international community, because the International Competition Network, like most international organizations, is a consensus-based organization, and as a consensus-based organization, you essentially can have a veto. Any significant player can have a veto over any significant progress. So the ICN, literally for a decade, throughout the Obama administration, the U.S. was trying to promote due process around the world, and the best we could get was very, very loose, soft guidelines. There were guidelines for, you know, the way we did merger review. There were guidelines for the way we do procedural enforcement of antitrust laws, but we couldn't even get the highest level within the ICN, which is called a recommended practice. We couldn't even get a recommended practice within the ICN because of the fact that there was just resistance by a few key players. So what do you do in a world where the only real game in town is either a consensus-based organization like the ICN or a consensus-based organization like the OECD, which is, you know, the rich countries club of, you know, 35 leading economies, and both of them are going to be resistant to any significant change. So, Macon Del Rahim's idea, he had been the deputy assistant attorney general in the 2004-2005, he saw this problem and said, we're never going to get anything major done on due process if we try to do it inside the ICN or inside the OECD. So he said, let's just go around them, right? Let's just circumvent that process and create a coalition of like-minded agencies that are leading agencies and basically promote this as a group of, you know, 10 or 15 key agencies that want to promote fundamental due process. And so he hired me because I have a background in international law, and we both together agreed that we should try to take this approach. And so over the course of late 2017, early 2018, we began basically shopping this idea with all of our friends and allies around the world. And there was a lot of enthusiasm about the norms, right? Let's have fundamental due process norms. But a lot of skepticism about the process, going outside the normal channels. And so that's essentially where we were for much of late 2017, early 2018, is how do you convince people that we should do it outside the system in order to maximize the chances of actually getting something really, really positive accomplished. The breakthrough really happened when we agreed that we're not going to take the previous approach and focus on sort of maximalist, ideal best practices, which had always been the practice in the past. You know, this is what everyone should be doing, right? Focusing on the ceiling of maximum best practices. Instead, focus on the floor, right? No one can do this kind of stuff, right? There's a minimum level of fundamental due process that everyone has to respect. And if we focus on the floor, then basically what happens is all of the leading agencies easily satisfy that floor, right? And what you're really then trying to do is promote this minimum standard to 140 other agencies, but it's really, really easy to get, you know, the leading 20 agencies to say, of course we do all of that, absolutely. So that's what we did, and we got 12 countries with regional diversity: Brazil, Chile, Mexico, Canada, Singapore, Japan, Australia, New Zealand, United Kingdom, and the European Commission to negotiate this document of minimum new standards, like bare minimum. And you have on your handout there the examples of the kinds of things that are in the sort of document of minimum due process standards, and the things that you would expect, right? Non-discrimination, access to counsel, attorney-client privilege, respecting confidentiality of, you know, documents, judicial review, written decisions, the core things that every agency should be respecting. And so that group of 12 negotiated those norms, and then the real question was, should we view these norms as similar to a cooperation agreement or a competition chapter in a free trade agreement that we could basically agree as a group to sign outside the normal channels of OECD or the ICN, or should we embed these norms within the ICN and run the risk that one or two key countries can block it and prevent it? And so that was the real debate in the course of 2018. In the sort of spring and summer of 2018, the norms, the substantive norms, were agreed to in negotiations over the course of the summer. Mekin Darahim has a speech on June 1st of 2018 announcing that we're going to be doing this, and that we're going to be doing it outside the ICN, but it was very, very clear that a lot of countries were resistant to doing that because they thought that it might potentially, even though there was never an intention to that, create a new international organization. And so there was resistance saying if you did this, then it would be essentially a treaty-based organization that would compete with ICN and OECD. So there was enthusiasm about the norms, uncertainty about the process of developing these norms. That came to a head in the early fall of 2018 in New York in September, in which essentially the Europeans said that we completely agree with the norms, we could sign the norms right now, but we will do everything we can to stop them from being accomplished outside the ICN. And Vestager gave a speech at Georgetown in September. European Commission Vestager gave a speech about this in September of 2018, saying we like the norms, we don't like doing it outside the international organization. And so we were in a quandary because our negotiating parties were split about whether or not they should try to do it within the ICN and do it outside the ICN. And then in November of 2018, there was another large meeting of 47 competition authorities in which they said, let's give the ICN a chance. Let's give the ICN to do something like this within the ICN. And so from November of 2018, essentially even the negotiating partners that worked with the DOJ and the FTC on promoting these norms said, let's pause doing this open for signature arrangement with the framework that we were developing and give the ICN a chance. So our view was very much that that would lead to significant delay and dramatic likelihood that these norms would be diluted, that they would be essentially diluted into something that wasn't really meaningful. And when I say diluted, I don't just mean the norms, I mean the mechanisms for implementation of the norms. So you had these core norms, but you also needed to have some meaningful implementation mechanism to promote those norms. And so when we were working on the framework, we were looking at all treaties of all types in every subject matter to try to see how do states implement their obligations under existing treaties, right? And it's essentially, it's a continuum. If you look at like how states comply with their international obligations, you have at the one extreme end you have just pure, there's lots and lots of treaties just say, in the event of a dispute, the parties will negotiate. You know, very, very soft, informal, diplomatic solutions. That's the far end of the spectrum. At the other end of the spectrum, you have treaties that say in the event of a dispute, the parties will submit their dispute to a standing international tribunal, right? And you have that with the International Court of Justice, with the WTO, with various human rights treaties. There's a lot of treaties that say in the event of a dispute, send it to a tribunal. We knew that would never get passed in a million years, right? We knew that from competition chapters in free trade agreements and others. They never agreed to submit. No agency, no competition agency has ever agreed to submit their processes to the review of an international tribunal. So those are the two extremes, and we knew neither one of them was going to be successful or significant. So in between, what can you do? Between pure diplomacy and binding treaties, well, you could step one back forward and say you could have an arbitration, and it could be either pre-dispute or post-dispute arbitration that might be a possibility. That's a possibility. Or if you don't do arbitration, you could have mediation, right? You could have mediation of disputes with a mediator that could potentially agree to mediate disputes between either agency-to-agency dispute, or you could do the person who is complaining of the misconduct, that is a party appearing before the agency, having them essentially have the right to seek a mediation. We were very skeptical that that could be possible. So then you go to like one step before that, what could you do under existing treaties? And then you look at other treaties. You could, for example, similar to the corruption treaty, you could have an expert consultant review compliance. You have an outsider review compliance. But then, of course, you run the risk of who picks the expert and how soft or hard are they going to be in the way that they do their reviews. You could create a private right of action, like in the dual taxation treaties, where every person complaining of mistreatment by the tax authorities has the right to seek a private right of action. You create a private right of action for that complaining party. We knew that that was probably not going to be successful. And then we hit upon the fact that the Hague Private International Law Conferences regularly do these treaties in family law and custody law and contract law, like the CISG. And if you look at the Hague process about the way they do implementation, they do something very, very creative. And that is they have, in addition to negotiation, private negotiation between parties about problems that they have two things. They have, in these various treaties, they have a self-assessment where you periodically do your own assessment of your compliance with it. And then secondly, they have a plenary review session every 5 years, where they look at how we, as the group of signatories, are complying with these obligations, and then they issue a report about their general implementation, not naming and shaming, not specifically calling out countries, but saying just a periodic assessment of how we're doing, right? And so we're thinking it's possible that that level of enforcement might work. So the draft that we proposed and it was adopted included no mediation, no arbitration, no outside expert review, but it did include three things, and that is the right to negotiate, bilaterally or multilaterally, the requirement to self-assess, to self-report, because once any of you that have been on faculty and your dean asks you, like, tell me what you did the past year, right? You know, all of the promises and goals and objectives that you had, those are painful memos to submit to the dean because you have to like remember all the stuff you said you were going to do and whether or not you've done it. Essentially, that's what it is. It's a self-report of compliance with the obligation. And then the third thing that we did was have periodic assessment of everyone together gathered about compliance. And the hope is that those three things together were sufficient to create likelihood of success. As a student of international law, I know that there's really only three ways that nations comply with international law. It's fear of punishment, economic or physical punishment, reciprocity, you know, we won't kill your prisoners of war, we don't kill our prisoners of war, and reputation, right? We are an upstanding member of the community, And we knew that reputation, far and away, was going to be the thing that would really drive success with this, because you may not fully appreciate it as a private practitioner or an academic or someone who watches the way these agencies interact with one another, but these agencies meet with each other all the time, like all the time. And they are in Paris twice a year. They're at the ICN annual meeting. They're at the ICN cartel network. They are constantly interacting with one another. And they care about their reputation in that community. And so the thinking was, if we get all of the major players to sign, then all of the middle tier and lower tier agencies will feel the obligation to sign as a matter of standing, as a matter of reputation. And so we were able to get, all of the major agencies in Europe, all of the major agencies in Europe, all of the major agencies in South America and in North America, and in Asia, we were able to get Australia, New Zealand, Korea, and Japan. We still are waiting, and then a few months later, India. So we're still waiting for China and Taiwan. They, I think, are going to feel pressure to sign, but the fact that we got, broad, significant support with all of the major agencies, I think it's a really good sign of likelihood of more and more agencies signing. I gave you on the sheet of paper the 72 agencies that have committed. And the funny thing is they even compete within a country, right? So everyone knows about the friendly competition between the FTC and the DOJ. That's very well known to the antitrust community. But within Korea, the KMOJ, which does criminal enforcement of antitrust laws, competes with the KFTC, which does civil enforcement of antitrust laws. And the KMOJ wanted to be the first signatory on the first minute that it was open for signature. And so I said, well, that's easy for you because it's daytime on May 15th, so you can just sign at lunchtime at 12:01 on May 15th. And KMOJ signed as the very, very first signature at 12:01 on May 15th, to the chagrin of the KFTC, because they are the civil enforcers and they view themselves as the lead antitrust agency, that the KMOJ wanted to sort of stick it to the KFTC, as I know we're a major player in enforcement as well. So, so the reputational dynamics works not only across countries, but even within countries in terms of compliance. So that's basically what happened in terms of enforcement. So the ICN took over the drafting of the framework in November, and then in February produced a draft that was incredibly high quality, and then it opened up for signature by the steering committee of the ICN, which is 25 leading agencies around the world. There was unanimous support for the framework by the steering committee, which includes Russia, India, North American countries, European countries. That was unanimously approved in April of 2019, and then it was open for signature in May, and by May there were 62 countries that signed, and then by August there were 72 countries that signed. So it was a pretty successful accomplishment. The real question is, why did the ICN go so fast when they had been waiting and delaying for 10 years and gone so slow for 10 years? And we think that the reason for that is that we basically said, we're going to go ahead with this with or without you, right? We're going to do this framework with a coalition of the willing, with or without you. And we said, along with a half dozen other countries, we will support doing it within ICN as long as it's not delayed and as long as it's not diluted. But if it's diluted or delayed, then we will get, and we will do everything we can to get, a handful of other countries to join with us outside the ICN. And so they felt this interest and pressure, we think, to support it and do it in a really, really fast way. And then, to their credit, under the leadership of the German Competition Authority, they really, really pushed for a strong document in an expeditious fashion. So that's where we are now. Just a few more minutes. Where are we headed next? So they had the first meeting of all of the members of the framework on competition agency authority in June. in Paris, and then now this coming November, 3 weeks from now, in Paris, they will have the first meeting of the ICN members to review the template, the self-reporting. So 6 months into it, every agency is supposed to report on their compliance with the framework, and that compliance document of every country should be posted on the ICN website. So now, for the first time, companies that are appearing before agencies around the world will know what these agencies do with respect to fundamental due process. So that basically is the major development that I wanted to talk about, and I'm happy to take any questions.
So questions for Roger?
Richard.
I'm not incredibly familiar with ICN and sort of cross-country negotiation methods. But one of the things that I think about, and I would love if you can expand on, is kind of collateral to your talk. How do you deal in this kind of framework with countries that have explicit industrial policy that they import in antitrust? You know,
Right.
thinking China, they seem like they're playing across a whole spectrum of policy controls, and they're kind of importing different grounds into others.
Right.
I'm sure we do that too. I feel like Europe and the United States probably does that less so because we have more public exposure to our processes. Does this kind of framework help to control that sort of industrial policy manipulation, or does this take everything on face value and we need to use other tools to address that?
No, it's a great question, and it's absolutely a critical aspect of what everyone was focusing on when they dealt with this issue. So the language on in the principles in the annex to the document I sent you has a sentence there on non-discrimination. Each participant will ensure that its investigation and enforcement policies and procedural rules afford persons of another jurisdiction treatment no less favorable than persons of its jurisdiction in like circumstances. So essentially what we did is we imported the non-discrimination rules of the WTO and the non-discrimination rules of bilateral investment treaties, and basically said you have to enforce your antitrust laws against foreign competitors exactly like you would enforce the antitrust laws against your own domestic national champions. And so the hope is, the expectation is, that if that doesn't happen, which of course we certainly assume that there will be violations of that non-discrimination commitment, then there will be opportunities for negotiation or for periodic assessments about industrial policy, because there is absolutely the risk of industrial policy and discriminatory enforcement in the competition space. So basically the answer is we're hoping that the non-discrimination commitment will at least reduce the chances of that. China didn't sign, and China probably won't sign. I don't think there's any expectation. So what we've been selling, what the other agencies have been selling, is this is sort of similar to international law, customary international law. This is not just binding for everyone who signed it. This reflects international minimum standards, right? This is like the bare minimum of what agencies should do. And if you talk about it as sort of a soft law, sort of norm development, you would say, even if you don't sign, this is so fundamental that you are going to be held at the standard. That's the hope. Yeah. Who knows?
In looking at the list, I noticed that like Argentina is not there, pretty much all of North Africa and the Middle East. What is the prognosis for getting some buy-in from some of those places?
I think Argentina is very, very supportive. You know, they are going through political turmoil right now with, as you know, the election. And so I think that they were deciding to wait to sign on to it to see what happened with that election. But as you know, that I think is potentially going to be problematic. I think Argentina, though, for sure, looks at what Brazil, Chile, and Mexico are doing. And if they see that, Peru and a bunch of other countries, Costa Rica, Honduras, you look at the list, they're going to feel a lot of pressure to sign if the other leading South American countries are signatories. North Africa, to be honest, they're not active on hardly anything with respect to the ICN. Those countries are very, very small in the way that they enforce They're not an active player in the ICN or in competition law forums anyway. So it would be great if they signed it, but to be honest, we don't have stakeholders saying we have huge problems in North Africa, right? Because those economies are relatively small and those enforcement agencies don't have really, really active practices anyway. So I don't think North Africa is as significant as even sub-Saharan Africa.
So I have a couple questions, Roger. First is, at least the way I understood you describing it was that sort of one of the key breakthroughs was reformulating these as sort of minimum standards.
Right.
Which then to me raises the question of sort of how many countries out there that, and I assume part of sort of thinking about this is having a sense of how much difference those minimum standards are going to make.
Right.
So, first question is, to what extent are countries already complying with the minimum standards, in which case, is this, how much difference is this going to make?
Right.
And then the broader question is, and you might have sort of answered this already, is why antitrust, right? I mean, is there something special about antitrust that we want to do this? Is it just that the antitrust people were interested in it? Are there efforts in other, I mean, it seems to me like securities, consumer, any number of places where there are multinational companies that might well be affected by lack of due process in government procedures. And so why antitrust? Are there other efforts out there in other fields, either to expand this or in parallel with this? Might this have an effect as customary international law in these other areas as you sort of suggested? So,
well, I mean, to some extent,
the answer to this is probably a talk in itself. So,
to some extent, you can say that antitrust is behind the times. The fact that we already have done this with investment arbitration and with trade, some of these core ideas about market access and non-discrimination are already embedded into the trade and investment arbitration world. So in a way, antitrust is behind those trends. In terms of like why antitrust? Well, because there was a huge outcry about the way they were experiencing enforcement in key countries, right? They could just tell that there was a thumb on the scale for the national competitor relative to the foreign competitor, and they experienced this in multiple different market economies to the point that they were saying we've got to figure out a way to normalize this process. And it took
so really so I guess what that's suggesting is sort of the key provision in all this is the non-discrimination stuff.
Well, no, I would not say that. Those other key things, that they didn't really get to prove their case, right? They didn't have an opportunity to prove their case. There are some countries that are extraordinarily advanced on most aspects of due process, but for cultural reasons don't have attorney-client privilege, right? So Mexico, Japan, and Korea, none of those three, which are otherwise really strong in terms of due process, relatively speaking, they don't have attorney-client privilege, and as a result of these initiatives, all three countries are now actively trying to figure out how they can deal with attorney-client privilege. Civil law countries historically didn't have it, but most civil law countries have moved in the direction of promoting attorney-client privilege. So now Mexico is like recognizing attorney-client privilege, but only in the world of antitrust, right? Does this really matter if everyone is doing it? Well,
You just might answer that not everyone was doing it.
well, I mean, the real truth of the matter is that all of the leading agencies comply with almost all the fundamental norms. But more and more you see other countries that are really, really active that don't have the sort of tradition of the rule of law in the same way. And so this really puts pressure on them to live up to those standards, right? That's really what it is. An independent judiciary, an agency that's really making decisions on the merits rather than under political pressure, and then also all of the normal indicia of accessing and having a chance to really present your case. So yeah, I think the answer is that when you have 140 agencies dealing with this, and also I would have to say in the merger context, when you have a major merger of multinational corporations that has to get approved in a dozen different countries, and lawyers are watching the way things are being handled in some countries versus others, and just the massive differences in their experiences in some countries versus others, it's really, really frustrating for them to see, like, why can't there be greater coordination on due process? And so I think that's part of what's going on. Other areas of law, though, absolutely, there's absolutely no reason why you couldn't have something like this applied in other contexts like securities or tax or things like that. Absolutely.